You are watching Access LaPorte County Channel 97. Coming up next is the February 23rd meeting of the LaPorte County Election Board Special Meeting. You can find more information for this meeting at www.accesslaportecounty.org.
Recording in progress.
We're going to call this meeting to order. LaPorte County Election Board. Today is February 23rd, 2024. Please stand for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. Roll call. Heather Stevens.
Present.
What's your last name? I'm sorry.
Massa.
Therese Massa.
Present.
And Brody Schofter, I am present. Does anyone have a proxy today?
I do. Katie Bowen is my proxy, and she is present.
She is right there.
Yes.
And do you have a proxy today?
I do not.
And I do not as well. Approval of the agenda. Are there any corrections to the agenda? I would like to make a motion to amend the agenda to include number 2 under new business regarding the fines assessed on February 16, 2024. Is there a second?
I so second.
All in favor say aye.
A discussion about that.
Go ahead.
Is it possible to move that up right before public comment?
I wouldn't have any objection to that.
Right.
I would amend my motion to move that up before public comment.
I amend my second.
Okay. All in favor say aye.
Aye.
Aye. Do we need to bring up the issue of Mr. McCormick and his challenge? Ms. Stevens.
I think that I would make a motion to add that under new business.
I would second that. All in favor say aye.
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 Motion carries. Okay. And did we have the public notice posted for today's meeting?
We did.
And when was that posted?
That was posted Wednesday morning.
Okay. And the agenda was posted outside the door?
Correct.
Okay. Don't have minutes.
We do.
You do?
We do. That should be in your folders.
Any corrections to the minutes?
Yes, I do have a correction.
Yes.
On the second page, the third from the last sentence, there's a phrase, to demand, and I respectfully request that be changed to request. It's a more neutral and objective term.
I'd second that. All in favor say aye.
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 Thank
Any
you.
other corrections to the meeting minutes? Hearing none. They are approved. All right, regarding the issue of fines assessed on 2/16/2024, we've received guidance from the election division contrary to the fines assessed. So we're going to do a redo. Everyone's going to get notice, have a chance to hire an attorney. That's going to be my suggestion if we have to vote on that. So I would make a motion that we set a hearing 45 days to 60 days from now, send notice, allow people to present evidence, and then we discuss the issues of fines at that time.
I would also like to state that we have open committees from 2015, 2016. I would amend that motion to include that Taylor and I send out a notice to everybody with an open committee. Get in here and close it. If you are no longer, if that committee is no longer active, please come in and disband. And that way what's going to happen is we're going to start fresh and we're not going to be going back 2, 3, 4, 5 years. Let's give everybody an opportunity to get these disbanded and let's get a fresh start.
Okay, so your motion is to amend my motion to include sending notice to all committees, not just those that the fines were assessed?
Correct.
Is there a second to that?
I second that.
Okay, all in favor say aye.
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 Furthermore, I would move that we vacate all the fines assessed and the decisions made at the February 16, 2024 meeting with regard to the fines assessed.
Second.
All in favor say aye.
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 Aye. Thank you. Now it's time for public comment.
Rodney McCormick, 617 Union Street. The fines, I'm already in the process to appealing your decision. So you're telling me that you're taking back your ruling? I'm kind of confused with what you're doing right now. I can understand what you're trying to do, but it takes away my defense and asking for one of the reasons why I shouldn't be fined, because I was never given due process, which was a blatant violation. If we're going to be strict around about the fining of individuals, then you should be strict on what your ruling was and keep the ruling the way you have it. I'm going to move forward with my appeal for the record, but I just think it's kind of like it's confusing right now, because those who have been fined, they have the right to appeal to the probate court, circuit court, or superior court on the decision that was made, and they have a great defense to have those fines thrown out. I just wanted to break that for the record, and I'll reserve the rest of my time for my challenge. Thank you.
Thank you. Any other public comment?
Juanita Haney, 2695 West Joliet Road. Actually, my public comment is, I didn't know where could I find, well, I know it's not probably a question, it's a comment, but we would like to know, and maybe we can find it somewhere, what is the fines, like, I have no problem with the fines, but I don't know what the fines are being used for, like, what happens to the fines after they're paid. So if maybe in the future we can find that somewhere, it's posted somewhere, that'd be great.
Would you like me to answer?
Yeah, it just reverts to the county fund.
Yeah, it stays with the county election board.
Okay, and does it show like what it's utilized for?
Yes, the board would actually have to go to the council in order to spend that money. That money would have to be appropriated out into different funds for us to spend.
Okay, yeah, we were just wondering like what they were used for.
Yes.
Good question.
Sure. Any other public comment? Any public comment on Zoom? Hearing none, public comment is closed. Moving on to old business. Candidate challenges. First up, we have, I believe, 3 challenges against Mr. Richard Mrzinski. Is that correct?
Yes, Mr. Schaffner, at this time, I am not going to be hearing this challenge, and that is exactly why I have appointed a proxy, so I'm going to step down and let her come up.
Okay. So how this is going to work, just as a general housekeeping matter, the challenger is going to get to speak first, present evidence, they're going to be sworn in, then the challengee, the challenged, will be sworn in, present evidence, or their attorney, and then we'll make a decision. Okay? Is Mr. Mrzinski here? I see you in the back. Mr. Stevens, are you here right there? Mr. Stevens, would you like to come up?
Mr. President, will we be hearing this in 3 separate cases, or are we just
I think
running them all 3 together?
What's the pleasure of the board? I think we should do them one at a time.
I agree.
Okay. Okay. If you could raise your right hand, please. You swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
And state your name for the record, please.
Alan Stevens, Chairman, LaPorte County Republican Party.
So, Mr. Stevens, the first challenge that I see before me, dated, well, they're all dated the same. February 15th, 2024. Let's see here. Sorry, let me get myself straight here. Mr. Mrzinski. Challenges?
Yeah.
There it is.
It was from the last meeting.
Yeah.
From the February
Mine are out of
16
order.
meeting. Oh, I see.
Yeah. Okay.
So this has 3 challenges and then his.
Okay. So the first one states that the CAN 12 Statement of Economic Interest form appears to be faxed rather than have an original signature. Let's start with that one.
Yes, Mr. President. In looking at, do you guys have a copy of Mr. Mrzinski's CAN 12 that was faxed in from Florida?
We do.
Okay. So it's quite clear on those two papers that it was faxed. You can see the marks from the electronic transmission on the top of both documents. I would like to read Indiana Code 3-5-4-1.7, and it states, except as otherwise expressly authorized or required under this title, a filing by a person with a commission, the election division, an election board, or a county voter registration office may not be made by fax or electronic mail. And it is my contention that anybody can look at the CAN 12 and clearly see that it was electronically transmitted up to LaPorte County from Florida, where it was also notarized at.
Is that all you have?
On that particular one, yes.
Okay. Any questions?
Yes. Mr. Stevens, isn't it true that that was later on that same day filed in person, that document?
It wasn't hand delivered from Florida. It was faxed to LaPorte County,
Right,
and then the fax was hand delivered.
right. So it was brought into the clerk's office.
Correct.
Okay, thanks.
Any other questions?
No.
I don't have any. Okay, Mr. Mrzinski.
We don't want to do it all three at once. We want to let Mr. Stevens do them all.
I'd prefer to.
Frankly, the arguments of 23, or the arguments as it relates to the facts, and the arguments of
He's already speak to her.
You got to come up here.
Good afternoon. My name is Alan Cernick. I'm an attorney in Michigan City. I'm also representing Mr. Morinsky today. I have documents. I have copies, if I may approach and provide those to you for reference, either now or later.
Sure. I would prefer if we just stuck with this one at a time, like for this challenge, because they're all separate issues.
Sure. There you go.
Thank you.
You.
Thank you. Thank you. Thank you.
And then I'm going.
Thanks.
Do all of these pertain to the first issue?
And all three issues.
Okay.
So, and I'll make that.
Okay. Thank you. I appreciate that.
With respect, let me just set in the record here first, that I have provided the election board with 4 different documents. The first is Indiana Code 3-8-2-7, which I will reference here in a minute. The Supreme Court decision from 1935 of Loom versus Simpson, 194 Northeast 341, 207 Indiana 680 from 1935. And finally, Wyatt versus Wheeler, an appellate court case under 936 Northeast 2nd, 232 from 2010. In addressing the issue of the fact that it was a fax, as you pointed out, it was faxed from Florida, but hand-delivered by Ms. Berinsky's daughter to the election board. There is nothing in the statute that prohibits that. I would further call to your attention, under Indiana Code 382-7, subsection 7 II, even the statute contemplates permitting things from their original copies. Quote, a receipt or photocopy, with the emphasis there, of a receipt showing that a statement of economic interest has been filed. Clearly the statute, while the statute that may be referenced earlier was from a different point in time as it related to the absence of any kind of modern technology, particularly in a post-COVID era, clearly the statute as it relates to candidacy contemplates other means other than original copies. You've noted also that the document was notarized, so we know Mr. Marinsky signed it and filed it. And I would also then call to your attention that the case of Wyatt versus Wheeler, in which it is noted that to disenfranchise voters because of a mere irregularity or a mistaken construction of the law by a party, a committee or election commission would defeat the very purpose of all election laws, which is specifically designed and authorized going all the way back to 1935 and every case thereafter, that election law should be interpreted as broadly as possible so as to permit any type of, so it's not as to permit or to discourage any type of disenfranchised voters or candidates for a particular, from serving in a particular office. I would also call to your attention that when we talk about disenfranchising voters and disenfranchising candidates, it is also in the opinion as related to Loom versus Sampson, where they note, as I just said, the purpose of the law and the efforts of the court are to secure to the elector an opportunity to freely and fairly cast ballots, to uphold the will of the electorate, and prevent disenfranchisement. In the absence of fraud, actual or suggested, statutes are to be liberally construed to accomplish this purpose. There has been no allegation that has been fraud, that Mr. Marinsky's signature or his completion of that form was through fraud or any other kind of malfeasance, and in fact, it is just the opposite. So to rule, even giving every benefit of the doubt, to rule that because it was not signed and executed in Indiana, in LaPorte County, would fall under the category of a mere technicality. And as the law clearly states, you can't do that. So that's my first argument.
So the Wyatt case is distinguishable from this case, though, in that the plaintiff was seeking to overturn an election that had already been held, and that's really where the disenfranchisement comes from, right?
Well, but it still stands for the overall proposition that all election laws, and there are other cases too, and the ones that I've provided, all election laws are designed to be as inclusive as possible and to not look for reasons to disenfranchise voters or look for reasons, no matter how minor, to disqualify a candidate from serving for office.
Any other questions? No. And I'm sorry, Mr. Cernick, did you have any questions for Mr. Stevens?
No.
As cross? Okay.
No.
Mr. Stevens, and are you done, Mr. Cernick?
Yes.
Do you have any questions for Mr. Cernick? Okay. Okay. So is there a motion to grant or deny the challenge?
Well, I move to deny the challenge because I don't see in the statute anything that specifically prohibits the action that occurred.
I would second that motion. Is there a discussion? And I'll start. Technically, it was faxed to someone, but hand-delivered to the clerk. To me, that doesn't violate the statute.
I think further, Indiana Code 3-5-4-1.7C includes that an electronic signature, and I'm taking out some of the verbiage, may be used for reports and statements filed under IC 3-9, and I would indicate that this is one of those times where an electronic signature by use of a fax machine was used, so I agree to the second.
Okay. All in favor say aye.
Aye.
Aye. That challenge is denied. Moving on to the second challenge. Mr. Stevens, there are no initials on numbers 7, 8, and 9 of Mr. Brzezinski's Can 2.
Correct, Mr. President. I believe
I'll remind you that you're still under oath.
the board should have a copy of the Can 1 filing. You can see there are multiple spots, 7, 8, and 9 that should have been initialed and were not initialed. And I'm going to go to IC 3-8-2-7. And it states the candidate must separately initial each of the statements required by this subdivision.
Which subsection are you referencing?
7DII.
Okay. Do you have anything else?
Nothing
This
further.
one? And Mr. Cernak, would you like to cross-examine?
No question.
Okay. You can step down. Mr. Cernak?
Unless I misheard him, which, given my age and given the fact that I wear hearing aids, is always a possibility. But I thought he cited 3827 subsection 7 or subsection 7D II. Am I reading that? Did I hear that right?
Yes.
And I read that to agrees to comply with the provisions of IC 39. I don't see where initials are required.
Keep going down. Last sentence.
Must separately initial. Okay, I see that. Again, I would go back to the argument I made before that I think this falls under the mere category of a mere technicality. When you look at what CAM 2 requires, the initials as relating to subpart 7 is as it relates to filing the statement of economic interest, which is CAN 12, which has been filed. So the mere fact that he didn't initial this particular form, however, did file contemporaneously with his declaration of candidacy, CAN 12 is the economic statement provided by the candidate. So again, I think that falls within the mere category, or the category of a mere technicality, and does not compromise the overall candidacy or viability or eligibility of Mr. Marinsky. As to the not apply, or as to being subjected to a surety bond, I have an affidavit from Mr. Marinsky, if you'd like, in which he is not opposed to posting a surety bond. He's never had to do it before in, 12 different years? 4 different elections he has served, both as a county councilman and as a prior commissioner, or as a current commissioner for LaPorte County. Never has been required to provide a surety bond. And as to the training, again, he's never been required to do training. The affidavit he has completed would also state he has no objection that if anybody were to require, or that the statute or the state government were to require him to undergo training specifically for being a commissioner, he would more than gladly do so. But again, to disqualify his candidacy on that basis would be contrary to a broad interpretation of all election laws.
So are you suggesting that 7, 8, and 9 are superfluous to this form and they're not necessary?
I'm not suggesting that.
Okay.
I'm suggesting they are technicalities to not be completed and understood, that they are to be required. I'm trying to provide, though, the one, that is not a basis on which to disqualify Mr. Marinsky, and the second thing is the fact that, if he were a newbie to elected offices in LaPorte County or the state of Indiana, I think it becomes much more important. But given 4 prior elections, never being required to post a surety, never being required to undergo additional training, quite frankly, it's an omission, and he should have completed it. That's acknowledged. But that itself should not be a basis on which to disqualify. And furthermore, given the fact of 4 different victorious elections and the corresponding 16 years of public service as a elected official, certainly would at least allow for the understanding that they were an omission, that was an inadvertent omission on his part, given the fact he'd have been required to do it beforehand.
Let me ask you this, Mr. Cernak. You suggested that a newbie would need to sign those and initial those.
I think everybody would need to sign them. I don't disagree with that.
Okay.
I think they become more important, though, for a newbie who, for example, a county assessor who has no idea how to do assessments, has no idea what property assessments mean. Well, he needs to undergo training for assessment. A county auditor who's never been an accountant before, who has never done managed public sector accounting, should undergo some kind of training. 16 years ago, when Mr. Marinsky was first elected to the LaPorte County Council, it may have been a requirement to understand budgetary matters, public sector accounting, public sector budgeting, if he had no experience in that. But that didn't happen, and again, it speaks of nothing else to the evolution of the law, that we've been electing people in the state of Indiana that may not have the qualifications or meet the qualifications to actually serve in that position without additional training by virtue of their prior experience. This county itself, I think we had a surveyor back in my lifetime dealing with this who had he got elected, but he had no idea of how to be a surveyor. He was never a licensed surveyor. And I think the statute addresses those kind of situations, that we may elect people that may not be the most qualified people for that position, and we do have training available to be able to do that. As to the issue of the surety bond, clearly, that speaks for itself. But again, as a commissioner, as a county councilman, that has never been asked of Mr. Marinsky before, he does not have personal access to county finances. He approves budgets, he proposes budgets, but he doesn't actually come in contact. His hands never touch cash. The idea of doing a surety bond would be important, say, for a treasurer. I get that. But again, I'm just trying to point out that I think Mr. Marinsky's oversight on that has to do more with 16 years of public service as an elected official in LaPorte County, where it's never been required before, and also speaks to the experience that he brings to this election.
Brody, can I interrupt real quick?
Yeah.
They need to be sworn in, the 2 of them.
I don't have to be sworn.
No, Mr. Cernak does not have to be sworn in.
And he's not going to give testimony.
Okay,
Yeah.
just checking.
Yep.
I caught that beforehand. So.
Any questions for Mr. Cernak?
No.
No. And Mr. Stevens, would you like to cross-examine?
So I see here, and Mr. Cernak, you'll have to forgive me, I'm a layman, not an attorney, so just a simple man. Says the candidate must separately initial each of the statements required by this subdivision. I don't see anything about only newbies must separately initial each of the statements required by this subdivision. I don't see where it says that because Rich Marzinski has been in politics in LaPorte County for 20 plus years, he's exempt from initialing. I'm a layman. I take it as face value. The candidate must separately initial each of the statements required by the subdivision. So, I don't know. Maybe, since I'm not an attorney, maybe somebody could verify.
Okay. Do you have any final argument?
At best, it's a de minimis omission. It's a de minimis omission. That's how I respond to her.
Is there a motion to grant or deny the challenge?
I make a motion to grant the challenge.
I'll second it. Any discussion?
It seems like a very minor omission, but by virtue of Mr. Mrozinski's experience running for office, it seems that he would know.
To piggyback off that, I don't see any wiggle room. It says that the candidate must separately initial each of these statements. Any comment?
It says the candidate must in 2 locations in the statute. It says it first in the preamble of Section 7A, and it says it further in the section that Mr. Stevens cited, which was 7D2. And the must is clear. It's not a may, but a must.
Being new to the board, I'm not aware of any recent precedent. I don't know whether that's something that enters into this discussion or not.
Neither am I.
Either to grant or deny.
Sure. So there is a motion and a second to grant the challenge. All in favor say aye. Aye.
Aye.
I'm going to oppose.
Okay, we have 2 in favor and 1 opposed. Motion carries. So under that challenge, Mr. Brzezinski's name will not be printed on the ballot. Regarding the third challenge, Mr. Stevens. I show that the third challenge states that Mr. Brzezinski is not a qualified candidate as he has been found by the LaPorte County Republican Party not to be a Republican in good standing. I'll remind you that you're still under oath.
Yes, sir. On September 15th, 2022, the Central Committee and the precinct people of the LaPorte County Republican Party took a vote at their monthly precinct meeting. The Secretary presented the definition of a Republican in good standing as defined in the Indiana GOP party rules, specifically Rule 1-25. Further explanation discussing Commissioner Rich Mrozinski's actions in the press actively degrading Councilwoman Connie Grammarosa, an active Republican candidate for County Commissioner. Extended discussion also supported the appearance of defiance from Commissioner Mrozinski against his documented party in many ways, publicly in meetings and in the press. Motion by Ron Schaefer to censure, rebuke, declare Commissioner Rich Mrozinski as not recognized as a Republican in good standing by the LaPorte County Republican Party. Seconded. Motion passes unanimously. And now to go to the Indiana Republican Party. Rule 1-12 says, bona fide candidate is a qualified primary Republican who has opened a campaign committee for a particular office or has filed a declaration of candidacy for an elected office or party office. Rule 1-24. Qualified primary Republican is a voter who cast Republican Party ballot at the 2 most recent primary elections in Indiana, which the voter voted, and who is also a Republican in good standing. The term Republican in good standing shall be defined as a Republican who supports Republican nominees and who does not actively or openly support another candidate against a Republican nominee. And Mr. Mrozinski, while being a Republican office holder, chose to make a contribution to Sheila Matias, which was reflected on her campaign finance report that was filed with the election board of $100. As we all know, Mrs. Matias was running for re-election against Councilwoman Connie Grammarosa, and Mr. Mrozinski chose to support the Democrat candidate. The county party has since filed a complaint with the 1st District Republican Congressional Committee. The Central Committee met. They found there to be warrant for a hearing, and a hearing will be held on the 11th of March. And at that time, we're going to request that Rich Mrozinski be banned from running as a Republican for the term of 10 years. Now, it was over in Lake County, the Lake County Election Board, Lake County Election Board versus Hero. Hero was a city or a town board Republican, held office, and he was supporting independents and Democrats. And the county party found him to be not in good standing, and Hero took it to the election board. The election board upheld that he couldn't run as a Republican. He could run as an independent or a libertarian or a, whatever, but he couldn't run as a Republican. Hero then took it to the U.S. court in Hammond. It went through there. They sided with the election board, and he then took it to the Seventh Circuit Court of Appeals, who also sided with the election board. And I just like to, again, I'm not an attorney, so bear with me. In making their decision, the Seventh Circuit Court of Appeals, they used Roberts versus USJC's from 1984. Quote, the forced inclusion of an unwanted person in a group infringes the group's freedom of expressive association if the presence of that person affects in a significant way the group's ability to advocate public or private viewpoints. Political parties enjoy these associational rights like any other organization, and no area is the political association's right to exclude more important than in the process of selecting its nominee. And they also went on to say the Supreme Court has emphasized with increasing firmness that the First Amendment guarantees a political party great leeway in governing its own affairs. And in the Democratic Party of the U.S. versus Wisconsin, it was ruled that political parties may accordingly protect themselves from intrusion by those with adverse political principles. So too can a state protect the First Amendment rights of a political party, as the election board did here by allowing the Republican Party to determine its own membership and restrict its standard bearers to members in good standing. And finally, we've got one more. It was David Duke versus the Georgia Republican Party. And twice the 11th Circuit sided with the state, saying Georgia has an interest in maintaining the autonomy of political parties, which means the Republican Party enjoys a constitutionally protected right of freedom of association. And again, I'm not an attorney. I appreciate you guys listening to me. And that really kind of concludes my presentation on the third argument.
So does he meet the requirements of having voted in 2 past primaries?
Correct.
Do you have copies of Hero versus Lake County Election Board? I've got it up here. I just want to make sure.
I have the 16-page decision from the 7th Circuit. If you guys want that, that's all I have on me.
Okay. Any questions for Mr. Stevens?
No.
No.
Okay. Do you have any questions for Mr. Stevens?
What was the date you said you had the Republican committee?
I'm sorry, you're going to have to come up so we can capture it on the record.
I should know better than that. I'm sorry. What was the date when you had that committee meeting to expel Mr. Berinsky from the Republican Party?
September 11th, 2022.
And was
Can you speak into the microphone, Mr. Stevens?
September 15th, 2022.
Was Mr. Berinsky given notice of that meeting?
It's an open public meeting.
Was Mr. Berinsky given notice of that meeting?
No, he wasn't given
Was
notice.
Mr. Berinsky given notice of the fact that his expulsion from the Republican Party would be an agenda item at that meeting?
No.
Very good. All my questions.
Does that bring any? Does that cross-examination bring up any follow-up questions for Mr. Stevens?
Sounds like a potential due process issue, though it's the Republican Party isn't a government entity, I understand.
Okay. Mr. Siernick, your turn.
I don't have a whole lot more to add to what you two just said. First of all, Indiana Code 3827, subsection 4, subsection A. A candidate is considered to be affiliated with a public party only if any of the following applies. Subsection A, the two most recent primary elections in Indiana in which the candidate voted as a Republican or voted in a primary. As Mr. Schaffner asked Mr. Stevens, the last two primary elections, the record reflects that Mr. Marinsky voted as a pulled Republican ballots as a Republican. As to the second argument, your due process argument, which is the same thing that I had. The 14th Amendment guarantees us the right to due process and the opportunity to be heard. Mr. Marinsky was never given notice of this meeting, was never given notice that the agenda item was to expel him from the Republican Party. Mr. Marinsky was never advised at any way, shape, or form that this action was being contemplated. The only way he learned on it was after the fact while reading a newspaper article about it. He's been denied due process. He also meets the statutory requirements of 3827. I would also like to mention that Mr. Stevens cited a case that had a 1984 date. I think that's what I heard. If you look at the very bottom of the Indiana Code 3827 that I submitted, it shows you where the history of that statute is. The most recent modification to this statute occurred in 2023, some 29 years after the 1984 case he cited. Whether that statute runs in violation of that law has never been challenged. And in fact, as recently as last year, the Indiana General Assembly said this is the way to determine a person's candidacy as related to either Republican or a Democratic candidate.
Is due process required for them to expel him?
I think due process is required in any kind of situation in which a person may have a deprivation of their rights and liberty.
So
I think the 14th Amendment has been interpreted that way for the past 200 years.
now I'm just reading this Hero versus Lake County Election Board for the first time. However, the Seventh Circuit did say that the election board did not violate Hero's First and 14th Amendment rights because of what happened with being ousted. So I'm trying to navigate that, and I need you to help convince me.
And again, the 14th Amendment guarantees due process. I don't know what the circumstances were on that, whether he was notified of that, whether it was proper notice, whether it was notice by regular mail versus certified mail, or all the other proper ways in which to provide notice. What I do know in this situation is that no notice was provided. No knowledge by Mr. Marinsky that this action was being contemplated. Nothing. Clearly, that's a violation of his due process rights.
Are you alleging the LaPorte County Republican Party is a state actor?
Just part of government, yes, they are. That's clear. Democratic Party, any government entity is a government actor. This board is a government entity. The Republican Party,
I agree with that.
And the Republican Party and the Democratic Party, as government entities, as political parties, must adhere to the same rights and responsibilities if they're going to restrict a member of their due process rights, of their liberties, of their any type of obligation or ability, and if it gets infringed upon. And clearly, if they're going to take this action and then not argue the next time Mr. Marinsky wants to run for office that he's not a Republican because we took this action without ever giving him any notice or due process or an opportunity to be heard to challenge that, then yeah, I think they do serve as a state actor in that regard.
So have you read this case?
I have not.
So this was sprung on me today.
Mm-hmm.
It's sprung on you. Would you like to take a recess from this so you can have a chance to read it? Because what I'm reading here does not jive with what you're saying.
Mr. Schaffner, I'm just going to, no, I don't need to do that.
Okay.
You've already voted to deny his candidacy on the basis of one, which I think is a draconian response to a mere technicality, and that we can address on appeal. No problem with that. If you do the same thing on this one, we can bring that up the second time as well. You know, it's obvious, you know, that the axis of evil to control the Republican Party wants Mr. Marinsky removed from this board. There's no question about it. They don't want him to serve as a commissioner anymore. But the case law that I have cited in the history for over 90 years would suggest that if they want to take this argument up, they need to take it up to the citizens of LaPorte County, not this board. For them to deny his candidacy, for this board to deny his candidacy, is a violation as a matter of law. I don't think we need to waste any more time whether we want to argue that. We can argue that again at a later point when we appeal your prior decision. And that's fine. We don't need to waste any more time here, and I'll certainly be prepared to do that when we challenge the other one. If you should vote, again, contrary to what Indiana law is, and deny his candidacy on the basis of the fact that he's not in good standing with the Republican Party, despite never being given notice. I guess the final thing I would say, Mr. Schaffner, is this. Indiana Code 3827 clearly identifies, and there's a host of case laws that support this, that it's not and. You don't have to vote in 2 primaries and you have to be in good standing with the Republican Party. It's one or the other. He meets the criteria in the fact that the last 2 primary elections, he's pulled a Republican ballot. The second one doesn't even come into play.
Counsel, can I ask you a follow-up question based on your notice argument? Was Mr. Mazinski a member of the LaPorte County Republican Party in September of 2022?
He was.
And did he ever receive any notice of their meetings or agendas or anything via email or how they typically post?
He did not receive a notice of this one. Based on what
September 2022 one?
Based on what Mr. Stevens said, yes.
Okay.
Okay. Is there any motion to grant or deny the challenge? Or would you like a few minutes? Sure. I'm ready when you are. Okay.
Mm-hmm.
Right. I will make a motion to grant the challenge. Is there a second?
I second.
Any discussion? I'll start. I think Hero versus Lake County Election Board is pretty clear that political parties can protect themselves from intrusion by those with adverse political principles, that it's not a violation of the First or 14th Amendment because he's not prohibited from running in the election, and that they can determine and restrict their own membership, and it is reasonable and non-discriminatory. Any further comment?
Yeah, this is a.
Will you ignore the statute?
Mr. Sirnick? No. Don't. We have procedure here. We're not going to lose it right now, okay? Thank you. Mr. Sirnick? Thank you. Comment?
Yeah, I think this is a really compelling case from the Seventh Circuit Court of Appeals in 2022. And, you know, there are clear arguments both ways, but I don't know how you overcome this case. There are options for other candidacies, and I can't get past this case with your arguments. I'm sorry.
You have any comment?
No.
All right. There is a motion and a second. All in favor say aye.
Aye.
Unanimously passed. Mr. Brzezinski will not appear on the ballot for this challenge as well. Okay. Would anyone like a break before we
Yes.
move on? All right, we're going to have a motion to take a recess, a brief recess of 5 minutes, or actually 10 minutes. Second?
Second.
All in favor say aye.
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 Recording stopped.
We're going to call this
Recording in
meeting back to
progress.
order. Please be seated. Call this meeting back to order. The LaPorte County Election Board took a brief 10 or 12-minute recess. And now we are on to Judy Davis, challenged by Lynn Swanson.
Before we move forward, Brody, do we need to have a proxy for this, or is Ms. Stevens?
That's up to her. Are you coming back up?
Yes.
Okay.
Thank you.
Thank you. Let me find it, please. Give me 1 second. First, can you raise your right hand? And do you swear or affirm under the penalties of perjury the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
And please state your name for the record.
Lynn Swanson, current LaPorte County Coroner.
And you filed a challenge against Judy Davis.
I did.
Is that correct?
I did.
Okay. And you can probably beat me to it as to what we're here for today.
Okay. I'm challenging because of item number 3 on the CAN 2 application. Ms. Davis has not voted in the most recent 2 primary elections on either party side, and she has also not received a letter from the party chairman.
And let's see. What party is this?
Republican.
Republican. Mr. Stevens? I'm sorry, is that all you have?
Yes.
Okay, thank you. Any questions for this witness?
No.
Okay. Mr. Stevens, if you could please come up. Do you recall giving a certification letter to this candidate?
I did not.
Okay. And I'm going to remind you that you're still under oath. Do you acknowledge that?
Yes,
Your answer's still the same?
correct.
Okay. Is Miss Davis here? Where? Oh, okay. Give me 1 second. Miss Swanson, you gonna come back up? Miss Davis, do you have any questions for Miss Swanson? If you want to come up and say that in the microphone, I'm sorry.
Not at this time.
Okay, thank you. If you want to raise your right hand, swear to tell the truth, the whole truth, and nothing but the truth under penalties of perjury,
Yes, I do.
and state your name.
Judy Davis, physician.
Okay. And how do you respond?
I have not voted in 2 primaries, but also I have not. I have asked on several different occasions for Mr. Stevens to supply a letter for me. He has never replied to any of my requests, so I was not aware that he would not write this letter, and so obviously I continue to go ahead and file for intent to run for coroner.
Okay. Do you have any documentation or other witnesses?
documentation as far as my filing.
Just anything.
Oh, the emails. I sent everything email, but I did not bring that stuff.
I'm not telling that you need anything. I'm just asking if you have anything.
No, I
else.
did not
Okay.
bring anything.
And no other witnesses?
No.
Any questions for this candidate?
I have no questions.
No, thank you.
Thank
Anything
you.
else?
Ms. Swanson, do you have anything to ask her? Okay. Is there a motion to grant or deny the challenge?
I move to grant the challenge. I think it's a very simple matter, and again, it's an unfortunate situation when you can't get what you want and need, but we can't change that. And the law states you have to have one or the other.
I would second that motion.
Motion has been made, and there is a second. All in favor say aye.
Aye.
Aye. That has passed unanimously. Ms. Davis, your name will not appear on the ballot. Lisa Reimenschneider for Mr. Stevens. You acknowledge that you're still under oath.
Yes, sir.
State your name for the record.
Alan Stevens, Chairman, LaPorte County Republican Party.
Okay, and so there are two challenges against this candidate. The first one, Lisa Reimenschneider has never voted in a Republican primary and does not meet the qualifications of a Republican in good standing. Proceed.
Correct. I've pulled from voters registration a copy of her Indiana vote history. She voted in the 22 general, the 20 general, the 18 general. There are no primary votes in Indiana on record. Thus in violation of the two Republican primary rule for running for precinct committeeman and or state delegate.
And so this challenge is specifically regarding Precinct Committeeman Cool Spring 2, and you have not issued a letter of certification for her?
Correct.
Any other questions for this witness?
No.
And
No.
is Ms. Reimenschneider here?
She called me prior to the meeting and said that she has students until 12:45. She would try to be here around 1.
It's 1:05. Would it be possible to give her
We
a few
can
minutes to get here?
table this.
Let's table this until later in the meeting.
Motion to table. There's a second. All in favor say aye.
Aye.
Aye. Moving on to Robert Rankin II. Mr. Stevens.
Yes, Robert Rankin II. I believe this is just a contest for precinct person.
So I have two of them.
And
let me remind you, you're still under oath. You acknowledge that?
yes, sir.
You're going to get tired of me here or saying that. The first challenge is for Precinct Committeeman Center 5. He's only voted in one Republican primary and does not meet the qualifications of a Republican in good standing.
Correct.
Proceed.
And I received information also that his, what year is this? Yeah, his prior to moving Indiana, his last vote in North Carolina was Democrat.
I see that he did vote in 2022 for Republican.
Correct. He has one Republican vote and does not meet the requirement of 2 Republican votes.
Okay. And you did not issue a letter of certification.
No, sir.
Any questions for this witness?
No.
In what way does he not meet the qualifications of a Republican in good standing?
He only has, per state law, he's only got 1 Republican vote.
Okay, so that's different than one vote in the Republican primary. Good standing is a different issue, isn't it?
You have to have two votes to run, according to state law.
I understand. Is good standing a different issue because you raised both issues on your challenge?
That may have, the good standing may have been inadvertent. I mean, I think according to the state party bylaws, you're automatically not a Republican in good standing if you don't have the 2 primary votes.
Okay.
Okay. Any other questions? Is Mr. Rankin here? Anyone on Zoom for Mr. Rankin? Okay. Is there a motion to grant or deny the challenge?
I'll make a motion to grant.
Would second that.
All right, all in favor say aye.
Aye.
Aye, that is unanimous. That Mr. Robert Rankin II will not appear on the ballot for Precinct Committeeman Center 5. Moving on to Robert Rankin II, Republican State Delegate at Large. Mr. Stevens, still under oath. Do you acknowledge that?
Yes, sir.
Would you like to rest on your previous arguments for the same challenge?
I would.
Okay. Any questions for this witness?
No.
Is there a motion to deny or grant the challenge?
I move to grant.
Is there a second?
Second.
There is a motion and a second. All in favor say aye.
Aye.
Aye. Motion has passed. Mr. Rankin will not appear on the ballot, and that was a unanimous vote. And he will not appear on the ballot for Republican State Delegate at Large. Okay. Moving on to Raymond Maloney.
Mr. President, members of the board, I would respectfully request that my two contests against Raymond Maloney for precinct person and for state party delegate be withdrawn at this time.
Okay. And why?
I was able to confirm that he had Illinois Republican vote history prior to moving here.
Okay. And is Mr. Maloney here?
Yes.
Would you like to say anything, sir?
Nope, everything is good.
Okay. For the record, he did say nope, everything is good. Okay. I'll move to deny the challenge this time. Is there a second?
Second.
All in favor say aye.
Aye.
Aye. Unanimous that the challenge is denied for Precinct Committeeman
Is that a
MC23.
denial or is that a withdrawal?
Deny the challenge.
Okay.
We're just ruling on the challenges. So deny the challenge. And then for Republican State Delegate at Large, same thing, Mr.
Yes,
Stevens?
Sir. Yes, sir.
Okay. I would move to deny the challenge filed against Raymond Maloney for Republican State Delegate at Large. Is there a second?
Second.
All in favor say aye.
Aye.
Aye. Unanimous that the challenge for Republican State Delegate at Large for Raymond Maloney is denied. Your name will appear on the ballot. Okay. Leanne Jones.
Mr. President, realizing that I'm still under oath from previous, I'd like to proceed that Ms. Jones does not have any Republican primary voting history. Her most recent primary vote was Democrat in 2006. And so I would respectfully ask the board to remove her name from the ballot.
Mr. Stevens, I noticed that the voting history that's attached has a different spelling of Ms. Jones' first name, and Jones is such a common last name. Is it possible we have the wrong person here?
It is the same address, so I don't know why there are two different spellings.
Well, frankly, I don't have her Can 1 attached. I'm sorry, not her Can 1.
Can
Her
37, I see.
is Brent Solers.
Yep.
I have Brent
Oh.
Solers attached. Okay.
That would be a clerical error.
Okay. Thanks.
And is Miss Leanne Jones here? Is Leanne Jones on Zoom? Nope. Okay. All right. Is there a motion to grant or deny the challenge?
I'll make a motion to grant the challenge.
I will second that. Any discussion? No? All in favor say aye.
Aye.
Aye. That is unanimous that Leanne Jones will not appear on the ballot for Precinct Committeeman for Kingsbury on the Republican ballot. Okay. Now we have Joe Maloney.
Although and I do realize I'm still under oath from previously, although I've got high hopes for Joe Maloney and his future with the Republican Party, because of his age, he doesn't meet the two primary rule. And we've had a discussion with him earlier, and because he don't meet the two primary rule, I would encourage him to go ahead and vote in the Republican primary and remain active with the party. But at this time, I contest that he meets the rule of law, as much as that pains me to do.
Any questions for Mr. Stevens?
No.
Not for Mr. Stevens.
And is Mr. Joe Maloney here? Would come on up. Swear to tell the truth, the whole truth, nothing but the truth, under penalties and pains of perjury, with the testimony you're going to provide today?
Yes, sir.
And what's your name?
Joe Maloney.
All right, you can put your hand down. And how would you like to respond?
I don't object.
Okay.
Can I ask a quick question?
Sure.
Mr. Maloney, how old are you?
22.
You're 22? And when did you move here?
3 years ago.
3 years ago? Okay, so you never voted in Illinois?
No.
Okay. All right, thank you.
Okay. All right. I'll make a motion to grant the challenge for Precinct Committeeman MC23. Is there a second?
I second.
Is there any discussion?
I don't like this one. He's young, and sometimes I feel like if that opportunity isn't there, I would have been, if he hadn't been so willing, I probably would have been inclined to vote his way. So, just for the record, that's all I want to say about that.
Any discussion?
No.
I don't have any. All in favor say aye.
Aye.
Aye. I'm sorry, I didn't hear you.
Aye.
Okay.
Thank you.
It's unanimous that Joe Maloney the challenge is granted for Precinct Committeeman MC23. He will not appear on the ballot for that. Regarding Republican State Convention Delegate at Large for Joe Maloney, Mr. Stevens, would you like to rest on your same arguments?
Yes,
And you acknowledge you're still under oath?
I do.
Okay. And Mr. Maloney, do you object to this one? I'm just trying to keep a record. I know it's cumbersome and tedious, but...
No, I don't object.
All right, thank you. All right, I will make a motion to grant the challenge for Republican State Convention Delegate at Large against Joe Maloney. Is there a second?
A second.
And any discussion?
No.
Okay. All in favor say aye.
Aye.
Aye. It is unanimous that Joe Maloney will not appear on the ballot for Republican State Convention Delegate at Large for the Republican Party. All right. Brent Stoller, challenged by Alan Stevens.
Yes, Mr. Stoller signed up for Long Beach Precinct Committeeman. His most recent primary vote was Republican in 16 and Democrat in 12, thus not meeting the rule of law of two Republican primaries back-to-back.
Okay. Any questions for Mr. Stevens?
No.
Is Mr. Solar here? Mr. Solar on Zoom? No? Okay. Is there a motion to grant or deny the challenge?
I move to grant the challenge.
Second.
There is a motion and a second to grant the challenge. All in favor say aye.
Aye.
Aye. It is unanimous that Brent Solar will not appear on the ballot for Precinct Committeeman of Long Beach on the Republican ballot. Next is Rex Bailey, challenged by Alan Stevens. Mr. Stevens?
Yes, this challenge was for residency. It was brought to my attention by a couple members of the party.
You acknowledge you're under oath, right?
Oh, yes, I do acknowledge that I'm still under oath. This is a residency challenge. Mr. Bailey and a couple of his LLCs own multiple properties in and around Michigan City, and according to Beacon, a lot of them tax bills are mailed to a address in New Buffalo, Michigan. This particular address he used to register for the precinct, 2525 East Michigan Boulevard, appears to be an apartment at a veterinary business. So I'm dubious about his residency. I mean, if he was here and could demonstrate beyond a shadow of a doubt that he lives above his...
Well, Mr. Stevens, the burden's on you. Do you have any documentation?
Other than an address in New Buffalo that his tax bills go to on Beacon, and I don't have that printed out right now.
Any questions for Mr. Stevens?
No.
No.
Let me know when you're ready for that motion, because I'm ready.
Just need a second. Is Mr. Bailey here?
I spoke with him yesterday. He called and said he's in Ohio, and he was trying to plead his case to me. I told him it had to go in an email so it could be presented before the board where you guys would each get a copy. He never sent it to me, so.
So as I'm looking on Beacon, it's deeded to Rex A. Bailey, and the address comes back New Buffalo for the property record. The property address is West 450 North. What address did he use here?
2525 and a half East Michigan Boulevard. And he does own that property, correct?
You asking me?
On that, yeah.
I don't know. I'm looking it up.
I believe Mr. Bailey and Mr. Bailey and his wife and a trust and Bailey Properties LLC, they own in excess of 10 properties, including the veterinary office in and around Michigan City.
Bailey's Properties LLC owns that property.
I would think that it may be reasonable for them to have somebody, all of their tax bills going to somebody else that isn't necessarily them.
That can happen.
Yeah.
So he's voted in Indiana since 2012.
Mm-hmm.
Without more information, I'm hesitant to do this because I'm almost certain this would be a crime if he was lying about his address. I mean, we're not stopped from looking into this further.
Right.
It's a matter of whether this challenge will be granted or denied. Unfortunately, the burden is on Mr. Stevens. And
Mr. President, I'd love nothing more than Rex Bailey to come walking up here and show me his driver's license and a electric bill, and I'd shake his hand and say, well, thank you, welcome aboard. But it was, as kind of the team coach and the captain of the party, I kind of get stuck bringing some of these complaints forward as part of my job.
And the language of the candidate filing challenge says the following facts are known to me and lead me to believe that the individual listed is ineligible. And you're not really giving us facts, you're giving some beliefs. So I don't think that the burden has been met.
I agree.
And I would move to deny the challenge.
Second.
all in favor say aye.
Aye.
Aye. Challenge has been denied. Mr. Rex Bailey will appear on the ballot for Precinct Committeeman MC20. Did we amended the agenda to add Rodney McCormick, I believe.
Correct. We still have Lisa to go back to.
Yeah, is Lisa here yet? Lisa Ryman Schneider?
And it is now 1:22.
Okay, well, we can cover Mr. McCormick's. Did a challenge for Mr. McCormick? Was there a challenge, or did he just withdraw?
Is Mr. McCormick still on Zoom? Excellent.
Yes, I am.
Okay, this was not challenged by another. This is a written challenge by Mr. McCormick. Basically, what he's requesting is, I don't want to speak for him, so I'd rather just hear it.
Sure. Mr. McCormick, can you raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth under the penalties and pains of perjury with the testimony you're about to give today?
I do.
And state your name for the record, sir.
Rodney McCormick Sr.
And what do you have to say?
First of all, greetings from Florida. I'm basically challenging myself after the John Russ challenged the two primary rule, and the downstate court ruled that it was unconstitutional. And we've been waiting on a ruling from the Supreme Court. I thought I can just go ahead and put myself on the ballot because he did the same thing as well. Unfortunately, the Indiana Supreme Court struck that down. They said, no, they upheld the law stating that you had to vote in 2 consecutive primaries. In this case, I've only voted in one primary as a Republican. Prior to that, I voted as a Democrat. So therefore, I'm not even a member. I'm not even in good standings with the Republican Party. And it's also when I signed penalties of perjury on my application. At the time, I did not knowingly intentionally try to violate the law, and nor am I trying to do it now. I am trying to just have myself not added to the ballot because I believe if I continue to move forward, I will be violating the law, and that means that I told a lie under the penalties of perjury. Once I seen that ruling, and sadly, I did not get the ruling until 4:30 on Friday from a county official, which I will not name at this time. When I read the ruling, it was kind of confusing because it seemed like they upheld the injunction. But again, there's no excuse here other than I have not met the 2 primary rule. I believe that several other individuals today was taken off the ballot because they didn't meet the 2 primary rule as well. Last week, Wednesday, I've been in Florida since last Wednesday. And if I may, Mr. President, I would like to call Al Stevens for witnesses and ask him 3 questions.
Certainly, Mr. Stevens. You've been called as a witness. State your name for the record, please.
Alan Stevens, Chairman, LaPorte County Republican Party.
Let me remind you that you are still under oath.
Yes, sir.
Mr. McCormick, please proceed.
Yes. Hello, Mr. Stevens.
Good afternoon.
At any time did I ask you for permission to run as a Republican?
No, sir, you did not.
Did you sign a letter of certification or give me permission to run as a Republican?
I did not.
At the time, you did have a full slate of candidates. If I may back up, Mr. President, I'm running for 2 different positions, and I'm going to be removed from both of them. One is the council at large, and then a state delegate. It's true that you had a full slate of Republican candidates at the time for the at-large seat, correct?
Yes, that is correct.
Do you know if I voted in 2 consecutive primaries as a Republican?
To the best of my knowledge, you have 1 Republican primary, most recently.
And this is very important. If you had, if Mr. John Russ was, if the court would have struck that down earlier, would it be safe to say right now that you or people from the Republican Party may have challenged me for the 2 primary rule?
Yeah, it's entirely possible, correct?
I have no further questions of Mr. Stevens, Mr. President.
Do you have any other witnesses?
No, I just have just closing.
Proceed.
This is a question of law. We all know that Supreme Court took a long time to make this ruling. The clerk did her best. I don't think she understood the ruling as well. A lot of us didn't. But the fact that they made that I believe that it's important. My integrity is at question now, and I don't want to I do not want to knowingly, intentionally violate the law. So I'm asking not to be placed on the ballot. This is also the precedent has already been set in this case. I believe that Stacey Benning, a county worker, I believe it was 4 years ago, she was placed on the ballot and she was removed at her request. Even though the deadline went by, the board voted unanimously to remove her from the ballot or not add her to the ballot. Mr. President, I'm very sorry for any inconvenience I may have caused the election board, but my fellow Republicans deserve better. I'm not in good standing, and I must remove myself at this time. I'm not forming a committee. I am not going to run. I'm not spending a dime. And I think it's right for the people of LaPorte County. And it's kind of hard to be honest in LaPorte County when you're dealing with politics. So I would ask for this election board to please have a motion to remove me not to add me to the ballot for 2024.
And Mr. McCormick, you're counsel at large for which?
Republican.
Does it distinguish the city or anything on that?
No, it's at large.
Okay, so
No, county at large.
state delegate.
County council at large, sir.
Mr. McCormick, state delegate, was that at large or District 1? Taylor?
That was at large.
At large. Okay, and Mr. McCormick, do you have any objection for us to proceed with one vote on both?
No, I have no objection, understanding that this is a unique situation.
Okay.
I think I'm the first one who has ever challenged their own selves, and I'm just going to do what's right by the law. Thank you.
I appreciate that. All right, I'll make a motion to grant the challenge. Is there a second?
I second.
And all in favor say aye.
Aye.
Aye. That is a unanimous vote that Mr. McCormick, the challenge that he filed against himself is granted to remove him from council at large as well as state delegate at large. Okay. With that one done, is Miss...
Thank you.
Thank you.
Please forgive me. Thank you.
Is Lisa Ryman-Schneider here? Okay. Well, give her 30 minutes. Mr. Stevens, if you'd like to come back up.
Mr. President, Alan Stevens, Chairman of the Republican Party, and I do understand that I was previously put under oath.
Okay. Precinct Committeeman, Cool Spring 2. Never voted in the Republican primary.
Correct. No Republican primary votes in the state of Indiana.
And does not meet the qualifications of Republican in good standing, according to your challenge.
No, sir.
Because of the two primaries as well.
Correct.
Okay.
Correct.
Any questions for Mr. Stevens?
No.
And last call for Lisa Ryman-Schneider. Okay. She has failed to appear. Was she sent notice, Taylor?
Yes, she was sent notice by mail Friday before our meeting, and then she was also emailed on the 21st, which was Wednesday, and then I spoke with her twice since she's received notice.
And when you say Friday before the meeting, you mean last Friday?
Last Friday before the meeting. Anybody
16th.
that I got a challenge form, yes, for, I sent notice to prior to the meeting because I wasn't sure if we'd get to the mail in time.
So all the challenges that we heard today, the notice was sent on February 16th,
February 16th,
and that was by mail.
that was by mail.
Thank you.
You need to untable this.
Oh, yes. We need to have a motion to untable. Forgot about that. Okay. Who wants a second?
I'll second.
Second. All in favor, say aye.
Aye.
Aye. It is now back on the table. Now, is there a motion to grant or deny the challenge?
I move to grant the challenge.
I'll second.
There is a second motion. All in favor say aye.
Aye.
Aye. Heather?
Aye.
Aye. Okay. It is unanimous that Lisa Ryman-Schneider will not appear on the ballot for Precinct Committeeman Cool Spring 2. Now, moving on to Lisa Ryman-Schneider, Republican State Delegate, District 2. Mr. Stevens. Same thing?
Same argument, and also realizing that I'm still under oath.
Thank you, sir. Okay. And last call for Mrs. Ryman-Schneider. Okay. I'll make a motion to grant the challenge. Is there a second?
A second.
Any discussion? Hearing none. All in favor say aye.
Aye.
Aye. It is unanimous that Lisa Ryman-Schneider will not appear on the ballot for Republican State Delegate District 2. That's all we have for old business.
Yes.
All right, moving on to new business certification of candidates.
We have to have the candidates approved. I would make a motion to approve all of our candidates, excluding these who were removed from the ballot today. I would like to make a motion to go ahead and certify those. That way, we have to have it done by the 29th. So as long as the two of you don't find any errors, I want to make a motion publicly that you guys can go ahead and sign.
And so just for the record, point of order here, the only person who was not excluded from the ballot today was Rex Bailey. Is that correct?
That's what I show.
Okay, thank you. And Raymond Maloney. Any other corrections?
Ooh.
This is why we do these things.
Yes, that's
Raymond Maloney and Rex Bailey were the only ones spared. I gotta have a sense of humor after the past 90
right.
minutes. The axis of evil. So I will second the motion. Any discussion?
Yes. Question, what happens if any of these folks successfully appeal our rulings today?
Well, that's what we would be notified, and then of course our ballot will be at a standstill until a ruling has come back.
Okay, so then we would have to recertify the ballot.
Correct.
Okay.
This is a preliminary.
Well, we're certifying because we
Okay.
have to turn this into the state, but they do have until
Got till the 29th
yeah, they have until the 29th.
to appeal it.
So I'm just trying to avoid an unnecessary meeting.
I understand.
So if nothing changes, our ballot is certified. If there is a change, I will contact the board.
Okay.
Very good.
End of discussion?
End of discussion.
Okay. We have a motion and a second. All in favor say aye.
Aye.
Aye. Board member comments. Who wants to start?
I'll start. You want to start?
Go ahead.
Okay. I want to say thank you to Katie for her work, her research, her time. You know, most of the time I'm fine. I have no problem. I have no problem with a vote for or against my husband. That wasn't the case. There was another issue that warranted the proxy. So, Katie, thank you. I appreciate your professionalism. Other than that, I told you guys it was going to be a heck of a year. So, whew, here we go. But I think we have a really good board, and I think that we're going to make sure that what we're doing is proper and we're doing it the right way. We can't, we're going to make a mistake, and when we do, we will correct it. So I think it's important to see that.
I think it's also important to recognize, and it's been an eye-opener today, to realize the importance of voting in primary elections for everyone who thinks that they may want to run, just for every citizen to get engaged at this early point in time. In LaPorte County, we have a very high voter registration rate. It's over 90%, and I think everyone should be really proud of that. I'm sure everyone in this room, everyone on Zoom, everyone who watches later are engaged enough to vote, but how about young folks like Joe Maloney? Everybody in your family, in your network, in your friend group, talk to young people about the importance of voting. And Heather, correct me if I'm wrong, is it true that 17-year-olds who are eligible, who are 18 by general election day, can still vote in the primary?
They can.
And they can still register to vote right now?
Correct.
And the deadline would be coming up soon. So 17-year-olds, talk to those young people about how important this is. Thank you.
Can I make one comment, please?
Sure. Just one.
Raymond Maloney.
Come up to the microphone.
Thank you. Thank you for allowing me to make a comment. Raymond Maloney. I just want to recognize Ben Ruiz, who helped me, and also Alan Stevens, obviously, helped me become a precinct committeeman on the ballot and delegate. Ben's running for Congress, 1st District, and I just wanted to point that out, that he did a lot of help to not only myself, but my son Joseph. Thank you.
Thank you. All right. I sat down with Taylor today and went through the forms that we're going to start sending out to remind people, because I know we're redoing those, the assessment of fines in a couple months, but I heard a lot of complaints about communication. So there will be no question moving forward that you will be notified approximately 30 days before reports are due. You will be notified as soon as it's late, and you will be notified of every hearing. After that point, I can't control what you choose to do or choose not to do, and at that point I have to do my job. But I will ensure, and I worked on them today, that they are standardized, that they are up to date, and that they will be sent out. So, just wanted to reassure everyone of that. Thank you for everyone who sat through this meeting. This must be better than cable, right? So, that's all I have to say. Thanks for coming. Thanks for being patient. And with that, can I have a motion to adjourn, please?
Motion to adjourn.
Second.
Second.
All in favor, say aye.
Aye.
Aye.